argue as you wish.
Thank you, Your Honor. May it please the Court, Stephen Funk, Bretzel Anders, on behalf of the appellants in this matter. This case arises from a complaint that was filed in municipal court for damages relating to the trimming of a tree by Ohio Edison and its contractor, Nelson Tree Service, under Ohio Edison's vegetative management plan. We submit that the trial court erred because she failed to dismiss the case for lack of subject matter jurisdiction, and also she erred because she found that Ohio Edison did not have the lawful authority and privilege to engage in tree trimming practices in accordance with its PUCO vegetative management plan. First, on the issue of jurisdiction, it is undisputed that the case involved a challenge to the trimming of a tree. And I say that because the trial court itself specifically found that this case was analogous to the Supreme Court's decision in Corrigan, because it essentially contested Ohio Edison's line clearance decision pursuant to its vegetative management program. That's on page 5 of the trial court's order denying the motion to dismiss. In Corrigan, the Supreme Court said that if a challenge relates to the question of whether a tree interferes with or threatens to interfere with electrical distribution lines, that is essentially a service-related question that falls on the administrative expertise of the PUCO, and that is a question that therefore is within the exclusive jurisdiction of the PUCO. In this case, the trial court agreed that Corrigan was on point, but it went on to say, I find that I have jurisdiction because the complaint is seeking damages. That we submit as error for 3 reasons. First, there's nothing in Corrigan itself that says that it was limited or that it did not apply to claims for money damages. In fact, in tree trimming cases, it's often the case that the tree's already been trimmed. So your remedy is going to be damages rather than injunctive relief. And there's nothing in Corrigan that suggests that that distinction matters. In fact, I think there's no case law that I've been able to find that says that Corrigan does not apply to a claim for money damages. The trial court just kind of came up with that on her own. And third, it was error because the decision is, the fact of the matter is that there is a statutory procedure, it's outlined in our appeal brief, by which a plaintiff can recover damages through the PUCO administrative process. It ultimately leads to a claim in the courts, but only after there's been a finding of a violation by the PUCO. So for that additional reason, we submit that the trial court should have concluded that there was a lack of subject matter jurisdiction. So if there's any questions about that, let me move on to the second point, and that is the trial court ultimately found that there had been a trespass. Now, the definition of trespass is the invading of another's property without lawful authority to do so. That's really the key. Now, in this case, Ohio Edison is legally required, legally mandated by the Ohio Revised Code to adopt and implement a vegetative management program in the Ohio Administrative Code to ensure the safe and deliberate, reliable distribution of electricity. Pursuant to that mandate, they have to adopt a vegetative management program that goes to, and is approved by the PUCO, that essentially grants them the lawful authority to engage in reasonable vegetative management activities in accordance with that plan. So the question here is, the property owner is essentially alleging that the Ohio Edison went too far, that they trimmed too much of his tree, or that the tree was not close enough to the lines to constitute an interference with the distribution of electricity.
But as a part of that claim, as I read the briefs, the court is saying that that your client has access to the poles and the lines that are over the tree line, the tree lawn. But the court seemed to put a lot of emphasis on the fact that there had been some accident, I guess, and one of the poles was damaged and the location was moved further north on 1 street, where I guess this intersection is. And when the lines then were erected, that they went over Mr.
Right, so what's interesting about that, Your Honor, is that that issue about the wires is really immaterial to the ultimate claim. The claim that was alleged, they did not allege that they weren't seeking an injunction, for example, to have the wires moved or to have the poles moved. If there had been that kind of claim, there likely would have been testimony, surveying testimony, expert testimony to determine whether or not the wires in fact went outside the right-of-way.
Well, are there any pictures?
I think there are pictures, but I don't think there's anything that definitively defines where the boundary of the right-of-way is. But
No, there was also testimony from the neighbor who had lived there for all these years and, talked about where the pole was before and where it was after the fact, and the court appeared to rely on that testimony.
But that's my point, Your Honor, is that that whole issue is immaterial to the claim that's being alleged. Because, let me explain why. They were not contending that the wires themselves constituted trespass, or that the wires should be moved. In fact, that would be outside the scope of the municipal court's jurisdiction. The claim that was alleged is that you negligently trimmed my tree, that you
Right.
related to the trimming of the tree.
But if the wires were only over the place, the area where your client had an easement over public property, then they would not have encroached on the tree, requiring the trimming that is the subject of this complaint.
Well, again, the question is, did they have the lawful right to have what the statute provides, is that you have the lawful right to install utility poles. There's no dispute that the utility poles are in the public right-of-way. At that point, now the question is, does the vegetative management unreasonably interfere with the reliable and safe delivery of electricity? Because if you have poles in the right-of-way, you have an inherently a right, an implied right, to be able to do preventive maintenance to ensure that those poles can operate safely and reliably.
So
That's the whole point of the vegetative management plan. So to get to your point about the wires, ultimately, there's no dispute that Ohio Edison has the right to have poles in the right-of-way. The question of whether the wires cross outside the right-of-way is really, one, not proven, but two, irrelevant to the ultimate question, which is, does the tree interfere with the safe and reliable distribution of electricity? Because if that's the case, Ohio Edison, pursuant to its vegetative management program, has the right to engage in preventive maintenance to ensure the safe and reliable distribution of electricity.
So for most people, I would imagine, where your client has established poles along the tree lawn on the street, that doesn't become an issue. But when it comes to someone who lives at an intersection, and this is the way, again, we haven't yet had the opportunity to look at the pictures, but where someone has property at an intersection, then you have an issue of impossible encroachment depending on how close to the intersection the poles are placed. Because then you have like a cross over the corner. And so if you can imagine an intersection here, and for whatever reason, this is hypothetical, it probably would never happen. This is the intersection at 90 degrees, and you would expect poles to be placed as close to the intersection as possible. But let's say they were placed way over here and way over here, and so the lines cut right across the middle of the property. That's my question about whether or not the trial court was addressing trespass under those circumstances.
Right, so let me explain it this way, maybe different. The claimed trespass in this case is the trimming of a tree.
Correct.
Okay? They're not contending that the wires themselves constitute a trespass, because if that were the claim, that was an encroachment, that therefore the wires need to be moved, that would be a claim that would be outside the jurisdiction of the municipal court. So ultimately, the wires, and where the wires were, is really an irrelevant question.
Well, it's not irrelevant, it can't be irrelevant.
Immaterial,
Because
yes.
it relates to why the tree was trimmed that is giving rise to this.
But that's the whole point, Your Honor. The vegetative management program allows for the trimming of trees if they endanger the lines, okay? So that's the ultimate question. Did the tree endanger the line? Now, I submit that that's a question ultimately for the PUCO because it has administrative jurisdiction. And that's true whether it's inside or outside the right-of-way. The question relating to whether or not there was a trespass is, did they have the lawful authority to trim the tree? Yes, they did, as long as it was in accordance with their PUCO management plan. That's the question that's presented. That's why getting focused on the wires was, I guess the better way of saying it is immaterial, because the issue before the court was not whether the wires encroached, because that would be outside the court's scope of the jurisdiction. The issue was whether the trimming of the tree was necessary for the safe and reliable distribution of electricity. There was no expert testimony or any other credible testimony that would say that it was not an appropriate preventative mechanism. And as I understand their argument, when you read the transcript, the argument that they were really making about the wires was not necessarily that the wires encroached. It was more that because the wires had quote-unquote been moved, therefore the tree was closer to the wires than it otherwise would have been. But that doesn't change the fact that it was close to the wires and it interfered with, or threatened to interfere with, the safe and reliable distribution of electricity. So when you look at the claim itself and ultimately the damages that the court awarded related to the trimming of the tree, that's a question that we submit, one, falls within the exclusive jurisdiction of the PUCO, but two, that as long as they were acting in accordance with their PUCO management plan, that they had the lawful authority to engage in the trimming of that tree. And that's really the key, because I think what the trial court ultimately found is that essentially she was operating on the premise that if your trimming only can occur within the right-of-way, only if it's within the public right-of-way, that would actually set a very dangerous precedent, because there's often going to be, if you drive down streets all the time, you're going to see utility poles in the right-of-way along if you want to call it the tree line. But ultimately, there could be lots of vegetation and trees that potentially endanger those wires or are a threat to endangering those wires. That's why there is a vegetative management program. That's why the PUCO has stepped in to regulate that process to ensure that there is necessary vegetative management control. And as long as you have the right to be there, which in this case, they have the right to install utility poles in the right-of-way, given that those poles are in there, given that it was beyond the scope of the municipal court to compel the removal of those poles, or the removal of those wires, at that point, the only question that's left is, does the wires interfere with the safe and reliable distribution of electricity? And that's why I submit that that's something that falls in the jurisdiction of the PUCO. And secondly, that there was not sufficient evidence to prove that that in fact happened, that it was not a safe and reliable preventative measure to trim that tree. So I want to make sure we're straight about the wires, because I really, and that was sort of the trial court and the parties kind of got into an argument about prescriptive easement, which ultimately was sort of irrelevant, because normally in a situation where you have an easement, say off of the public right-of-way, you get into the question of whether or not there was a valid easement or not, whether you had a prescriptive easement or not. This case, you have the poles in the right-of-way, so there is a legal right to be there. Whether or not the wires cross over is really irrelevant, because they were not seeking, I shouldn't say they were irrelevant, immaterial, because they were not seeking, they could have gone, say, to a court to compel the removal of the wires from the right-of-way. They didn't do that. They're seeking to say that you exceeded the scope of your vegetative management plan by trimming the trees.
Well, he's unhappy with the fact that this tree was unnecessarily
And there is a remedy for that. That's what the PUCO procedure's for, that if it
Well,
relates
what's its
to.
remedy? Make the tree grow faster and fill out again? Or
Well,
just
I
a
mean,
monetary?
there is a procedure in the Ohio Revised Code that would allow, if there was in fact a violation, that would allow for money
I'm
damages.
still a little confused about the right of way here.
Mm.
The poles, I'm not confused about, they're in the right of way. But let's say they're farther apart or the configuration of the property is different. Can the wires simply be strung over a longer distance? I know there's a point of no return where they would be lagging down, but how much of the airspace is permissible to be taken?
Yeah, I mean,
Which interferes in something that's been there before and longer.
yeah, and I don't know the answer to that question, because if you look at the record, it's a pretty small record, but ultimately in the record, everyone's talking about the tree line. Well, the tree line isn't necessarily the boundary of the public right-of-way. There was actually no evidence submitted by a competent licensed surveyor to show where the boundary of the right-of-way was. So there's no evidence to show that the wires in fact, other than just observational testimony from lay people, nothing that definitively shows that the wires in fact were outside the public right-of-way. But I guess my ultimate point is that doesn't matter to the outcome of this case, because the claims that they were seeking were not to move the wires. The claims that they were seeking was, you negligently trimmed my tree without the right to do so. And that's a question that ultimately is regulated by the PUCO under the Vegetative Management Program, whether they exceeded that program or whether they acted overly, violated that program. That would be something that the PUCO would have jurisdiction over. And ultimately, assuming that there was a jurisdiction, the trial court did not have sufficient evidence to say that that wasn't an appropriate and reasonable vegetative management practice.
Did
So-
your client bring in an expert witness to testify, to rebut the lay testimony of the plaintiff's witness regarding the areas of, that you just criticized, to show where the right-of-way was? Did
Well,
you see anything like that?
Again, that wasn't the issue in the case. They weren't seeking to compel the lines to be moved. What they
No,
came.
I know that,
Right.
but you just.
So the testimony that was presented was focused on the trimming of the tree. So what came in was an expert forester who talked about how they trimmed the tree because it was in accordance with their vegetative management program, because they determined that it was necessary to protect the safe and reliable delivery of electricity. That's what they were defending. Now, there was also testimony that related to when the poles were installed, 1982. But the issue of whether or not the wires crossed over, that was something that was raised at the trial by the plaintiff, but that was never really ultimately an issue in the case, because they didn't seek, the claim was not, you've encroached on my property because the wires crossed over.
Thank you, and you've gone over your time, but we asked a lot of questions.
Well, I
Thank you
appreciate
for your
that.
presentation. The court will take the matter under advisement, will issue written opinion, which will be sent to both parties.
Okay, and thank you. And it's my